My name is Adi Rao. I'm first year common law. My question is for Mr. Robert Walsh, and it's so just sort of drawing from current events and drawing from what you've just been talking about. I'm wondering if you could talk a little bit about the relationship between members of Parliament and the judiciary, in the sense that let's take Dean Del Mastro, who was quoted after having been convicted as saying about the judge that, well, it's just his opinion, I'm going to go appeal. And then now, today, we're seeing the Minister for Immigration, Minister Alexander, trying to deal with the recent order to reinstate refugee health care. And over the past few hours, we've been seeing the changes, or the reversion to what it used to be, sort of roll out. But the problem is, the minister sort of is kind of bringing those changes back in a way that may not necessarily actually amount to reinstating what previously existed, but just sort of, putting in what he feels like might fly in the meanwhile, and has said that he's also going to go ahead and appeal. So the question I have is sort of this relationship between a judge's ruling and parliamentarians. Do you have any thoughts on it?
The constitutional expert, Peter Hogg, developed a notion of a dialogue between the courts and Parliament that the idea was that the courts would make a ruling. Well, that's their intervention on the issue, and now Parliament can consider the issue and look at what the court ruled and perhaps come to a different conclusion and legislate accordingly, and then that may end up back in the court, and the court will have its response if it's given an occasion to have one, and so on, and this dialogue goes forward. But more specifically, and you mentioned the Del Mastro matter just now, and you mentioned another case with which I'm not familiar, but generally speaking, it's open to the House or the government to bring in proposals for legislation that may be designed to, in some manner, get around a ruling of the court or in effect nullify a ruling of the court. I mean, the courts make their rulings, fine, and then Parliament, and particularly the House of Commons, has the option to legislate as it sees fit and run the risk that may get nowhere because it may end up getting rejected later once again in the court. But it's perfectly understandable they could do that. And Mr. Del Mastro's comment about the judge, well, that's her opinion. Well, what can I say?
Thanks.
Hello, my name's Angela Arnott-Canitas. I was a former law student here, and I was also a former employee of the Department of Justice when Mr. Cotler was our minister. I don't know if I have the perfectly framed question, but it will be short, and it's for Mr. Cotler. What place do you see in the rule of law for the continuing use of the royal prerogative of mercy, which is in the criminal code?
Well,
That wasn't one of his 7 principles, so he's going to have to think about it.
No, well, one of the things that I did end up engaging in, which is, if you will, not so much mercy, but it is mercy in its consequence, but it's more an issue of justice, and that had to do with wrongful convictions. Again, this is something that I did not anticipate before I became Minister of Justice. I learned about the Truscott case as a law student as a case of capital punishment. We never learned about it as a case of wrongful conviction. Then afterwards, the power was vested in the Minister of Justice that where there was prima facie evidence of a miscarriage of justice, then the Minister of Justice had the authority at that point to either quash the conviction, and well, it was 2 things. One was he could send it to quash the conviction and order a new trial, or send it to the Court of Appeal for a fresh hearing on the merits. Now, in the Truscott case, I knew that if I quashed the conviction, there would be no new trial, because the Attorney General of Ontario had said that he would not proceed. So I then went to the next option, which was to, in fact, refer the matter to the Ontario Court of Appeal for a fresh hearing on the merits, which is what then ensued, and Trescott was, as a result of that hearing, acquitted. The question of mercy was not something that ever arose. The only way these issues arose for me were issues in terms of wrongful conviction. So I would have to take a look again at the royal prerogative of mercy, because the issue did not arise while I was there on that point.
Thank you.
Hi, my question is probably best suited for Mr. Walsh or Mr. Cotler. My name is Reem. I'm a third-year law student here at the University of Ottawa. I've been sort of perplexed by the interplay between judicial discretion and the royal prerogative and how the two clash. Lately, we've seen a lot of, I wouldn't use the term fettering, but perhaps crossing into the Rubicon of judicial discretion through legislative authority, through amendments to the Immigration and Refugee Protection Act, particularly the Citizenship Act, with respect to how judicial review is arranged and how judicial review is allotted and limited. So my question to either Mr. Cotler or Mr. Walsh is, how are we to deal as future attorneys and as attorneys in this room today with that clash between judicial discretion, or with that encroachment, so to speak? Is it an encroachment in and of itself on the separation of powers between the executive and the judiciary? Is it something that we need to flag as an issue going forward? Perhaps not just in the context of immigration and refugee law, but in other contexts where judicial review is limited or judicial discretion is limited.
Actually, before you answer that question, I'm going to ask my colleague Jennifer Bond to also ask the questions, because I highly suspect that her question is actually going to be on the same wavelength. So, and perhaps the entire panel can answer these questions, because I think, David, you also have a role to play in answering the first question too.
Thank you. Actually, I hate to bring up immigration and refugee law again, but it is a day, as Addie mentioned, where it's on the minds of many of us, because we've attempted, and by we, I speak on behalf of the advocacy community who's working to deal with refugee health cuts, to deal with the court process as a mechanism of engaging the rule of law. We were successful in court. We were successful in defeating a stay application. And today at midnight is the deadline for the government to restore health care to all categories of refugee claimants in this country, pending the outcome of an appeal. And I was actually going to address my question to Nathalie, but I certainly welcome reflections from any of the panelists. We have since heard from the minister just within the last few hours that they will not be complying with the order of the court. And subsequently, from their failed stay application, they will be partially restoring refugee health benefits, but not fully restoring them. So I guess my question is, in a time when we're attempting to use more traditional legal mechanisms to enforce constraints on power, given the responses that we're seeing, do you have any reflections on how the rule of law might be enforced outside the courtroom, and what that might look like? And I certainly welcome comments by any of the panelists, but I'm particularly interested in Nathalie's comments.
Thank you, Jennifer.
Well, I think the rule of law says if we have a dialogue, it cannot become a monologue. So in a way, but the price will be political. That's why I thought, you have to also give the indifferent and the civil society the power to say that's wrong. We cannot have disregard for the rule of law and disregard for a judge's opinion. And we'll see how they finesse this. And let's hear about tomorrow morning how they manage this. But I think fundamentally that's about this. All society should care. If it's wrong, then find the proper processes. If you think it's wrong, find the proper processes to debate this. But to say, well, it's just an opinion, but so I think that's the core. Is to ensure that within the government, within general people. People say it's a high price to pay to disregard the rule of law. And it's incumbent on all of us to make that voice heard.
It's ironic that government is performing civil disobedience, but anyway. Irwin?
I just, to connect to something that Nathalie said before and now in the questions, but the whole issue of access to justice and relating to disadvantaged groups and refugees being amongst them, it goes right back really to priorities and principles. How does a government frame its priorities and principles? And one of them that I did not have a chance to mention and amongst the 7, but it relates in this way both to Nathalie's views and the comments, and that is one of the principles that we try to establish as a government, that the test of a just society is how does the government treat the disadvantaged amongst it? How does it treat its most vulnerable? Whether it be children, the most vulnerable, whether it be women, violated women, whether it be refugees, whether it be Aboriginals, etc. And we sought to have this notion, and certainly as Minister of Justice for me, this was a Grundnorm principle. And on all these issues, on the matter of children, the first piece of legislation I introduced was protection of children and other vulnerable persons. In the matter of women, the first piece of legislation I introduced was with regard to trafficking in persons. With regard to refugees, I worked together with 2 ministers of immigration, where our approach was, how can we protect refugees and how can we grant them the proper access under the law to the benefits and services, etc., then we felt refugees would be entitled to. And as I say, there are 2 ways to approach it. You can approach the whole question of refugees and say we're going to designate countries as safe countries, there are no refugees from that country, or you can go ahead and designate certain places as being refugee-producing countries and therefore have a predisposition for conferring refugee status and then the services that follow. And the same thing with the Aboriginals. So for me, it came back to what is the government's priorities, what is its governing philosophy in its relationship to the people, to the institutions of government, how does it relate to Parliament, how does it relate to the courts, how does it relate to civil society. All that comes together, and in all these questions, you can see a distinguishable approach between the present government and the previous government or other governments in a manner in which they would relate to all the institutions of governance, including civil society.
Thank you. And last, Rob?
I do think, though, that going back to judicial discretion and legislative initiatives to try and limit that discretion, well, legislation can define the terms of any right or entitlement under the legislation, and that can have the effect of constraining the courts in its application of the statute. But of course, it runs up against ultimately the provisions of the Constitution, in particular the Charter. And if the legislation is trying to somehow deny the exercise of judicial discretion relative to the Charter, well, it won't work because the Charter is constitutional, and these pieces of legislation are just that, ordinary legislation.
I'd like to thank our distinguished panel for doing a great job here.